Hello and welcome back. Today we're going to discuss trial courts. Now, this is going to build off of Friday's lecture in which we had discussed the three forms of conflict resolution leading up to court action. We discussed negotiation, mediation, arbitration. Today we're going to discuss what happens when those three methods of conflict resolution fail and we must resort to court action. So, why do you need to know about trial courts? Well, first off, because if you're ever arrested for a crime, which none of you ever will be, but if any of your friends are ever arrested for a crime, their case is going to begin at a trial court level. The second reason why you need to know about trial courts is because if you ever need to sue someone for money, your case is going to begin in a trial court. The third reason why you need to know about trial courts is because only the trial court level can determine the issues of fact in a case. It's the trial court level that determines the facts. Appellate or appeals courts do not deal with issues of fact. What do I mean by this? Well, this is a chart that I want you to get very familiar with over the course of this unit. I'm going to keep coming back to this. Make sure you know this by the end of this unit. So over here, we have this chart. On the right-hand side, you have three different levels of courts leading up to the Supreme Court of the United States, which is the court of last resort, the highest court in our entire nation. That is the Supreme Court of the United States. These are all state courts. All 50 states have their own court system. Illinois has a court system, Ohio has a court system, Indiana has a court system, Michigan has a court system, and so on. Across from the state court system, you have the federal court system in this country. So you would have, by federal I mean the national court system, the nation's court system. So you have a court system that deals with federal law as opposed to state law. You have two courts that lead up to the Supreme Court of the United States. Remember, the Supreme Court is the court of last resort for both the state court systems and the federal court system. All roads lead to the Supreme Court of the United States. Now today, we're not dealing with this court, or this court, because all of those, as well as the Supreme Court of the United States, are all appeals courts. Your case will never begin here, and only in the rarest of circumstances might a court case begin here. But just about every single court case begins either at the state trial court level or at the federal trial court level. Now, it's important to note that at the state level, or in the state court system, we just call these state trial courts, or the Illinois trial court. Over here in the federal court system, federal trial courts are called U.S. district courts. Why aren't they just called federal trial courts, which would be so much easier to remember? I don't know. I did not name them, but I do want you to remember that U.S. district courts are just the federal court system's version of a trial court. We're going to be dealing with these two lowest levels. So, what do trial courts do? Trial courts are exactly what you see on TV all the time. I mean, what you see on TV are not appellate courts. I don't think I've ever seen a court show that has shown an appellate court process. They're almost always trial courts. So, trial courts listen to testimony, consider evidence, and decide facts. When I say consider evidence, evidence is anything that may come to be important in determining the guilt or innocence of a defendant in a criminal case or liability in a civil case. So there are two parties in a trial court level. You have the plaintiff versus the defendant in civil court. And we had discussed that when talking about the difference between criminal law and civil law. The plaintiff in civil law is the person bringing a lawsuit or bringing the complaint against a defendant. So the plaintiff sues the defendant. Now, in criminal law, which is really what we're dealing with in Law 1, this course almost exclusively deals with criminal law. You have a prosecutor, which always represents the government, brings a case against a defendant. So a defendant would have been arrested, charges are brought against that defendant, and it is the prosecutor that brings the case against the defendant. So evidence in trial courts are provided by witnesses. There are no witnesses at the appellate court level. Only in trial courts do you hear testimony from witnesses, do you hear evidence that is presented by witnesses, and then facts are determined. Once a trial court's decision is made, the losing party may only appeal to an appellate court if an error of law was allegedly committed. An error of law. I want you to remember that you cannot just appeal because you're upset that you lost the case. Of course you're upset you lost. It doesn't feel good to lose, but you don't get to appeal to a higher court just because you lost. You have to claim that there was some sort of procedural error or a constitutional error that was made. So for example, an example of a procedural error might be the judge had read incorrect jury instructions to the jury, and as a result, it may have swayed jury opinion in one way or another. So therefore, this would constitute a procedural error, an alleged procedural error that you can appeal to a higher court. We're going to discuss first the inquisitional court system because that is not our system. Our system in the United States is what is known as the adversarial court system. So let's first discuss that inquisitional system. The inquisitional system, and this comes from the word inquire. Maybe you have heard of the word inquire before. But inquire is a fancy term, a very sophisticated way to say that you are asking a question. So if you were to email somebody and say, I was just emailing you to inquire that the time of our meeting, something like that. You are asking for the time of the meeting. So the inquisitional court system is mainly used by European countries. Now, the theory in this system is that the judge will be able to determine truth by actively questioning witnesses and controlling the court process, including the gathering and presenting of evidence. So in this type of court system, then the reason why it's called the inquisitional court system is because the judge is inquiring. The judge is asking questions of witnesses. The judge has the ability to conduct searches. The judge has the ability to comment on evidence. The judge takes a very active role in the court process. So to give you an idea of what this might look like, you take Judge Judy. Now, Judge Judy is an actual judge. It's not just a TV show, although it is court TV, so it is made for TV. But she is a real judge. And Judge Judy, the way she operates her court is in an inquisitional manner, because Judge Judy is calling evidence to be presented in front of her. She'll question witnesses about evidence, and she takes a very active role in the court process. But know that Judge Judy is not an accurate representation of how our court system works in the United States. Rather, we have what's known as an adversarial court system. Now, adversarial comes from the root word adversary, and an adversary, some of you may know what that word means. An adversary is an opponent. So, Elgin's main adversary is Larkin. It is our main opponent, our arch rival, for example. So, an adversarial court system is used by the United States, and it is a contest between opposing sides, or adversaries. Now, the theory in this system is that the judge or the jury, and we'll talk in a minute about when you would only have a judge determining a case and when you would only have a jury determining a case, but the theory is that the judge or the jury will be able to determine truth if each side presents their best arguments and exposes the weaknesses of their opponent. So this differs from the inquisitional system, in which you have both sides that are trying to work together to uncover truth. But in our system, the adversarial system, you have two opponents that are working against each other, and they're actively trying to present their best arguments, but they're also working against their opponent and exposing the weaknesses of their opponent's arguments. There is criticism of our court system. Critics claim that it is not the best method for discovering truth with regards to the facts. Saying if you don't have two sides that are working together to uncover truth, rather you have two sides that are just working against each other to win, that's not the best method for exposing justice. So the goal in this system, critics claim, is victory, not necessarily truth or justice. And other critics also claim that lawyers act as enemies, making every effort not to present all evidence in the adversarial system. That if there's a weakness to your arguments, you're trying to keep that covered up, and you don't want that damning information to be exposed in court. Now, supporters of this system claim that approaching the same set of facts from two different perspectives will actually uncover more truth than other systems. And by other systems, we're pretty much talking the inquisitional system. Now, with the adversarial system, it may be a good example of this. I was watching a TV show on HBO, and it was called The Night Of. It's a mini-series, awesome series. You guys should check it out. But in The Night Of, it's a story of, or it's a show about a college student who ends up taking his father's taxi cab for a joyride, picking up this girl. He goes back to her place. They end up drinking, doing drugs, and anyway, he falls asleep that night, wakes up, walks upstairs, and she's stabbed to death. Well, he is arrested for her murder. He's sitting in the jail cell waiting for his attorney to show up. His attorney finally does show up, and he's understandably frustrated, and he's worked up, and he tells his attorney, I just want to tell the truth. Like, nobody will listen to me. I just want to tell the truth. And then his attorney says, hey, whoa, wait, hey. The truth does not matter. The beautiful thing about our system is that it is their story versus our story. And the one advantage we've got is we get to hear their story first. That's the adversarial system here. This attorney in the show is trying to get the point across that the truth does not matter. Rather, we're going to tell a story, they're going to tell a story, and we're going to see which one the jury likes best. So the judge, let's talk about the role of a judge here. That you all have the wrong idea of what a judge actually does in court. And you have this misconception because of media. That when you're watching TV shows and movies, the judge usually takes a very active role in a lot of court dramas. But the judge's role is not a very active role. The judge's role in a trial is usually to preside over the trial. Or act like a referee in the trial. But our judges in the adversarial court system that we have in the United States, they don't take an active role questioning witnesses. They just kind of serve as the referee, and both the prosecutor and the defendant in criminal law, or the plaintiff and the defendant, those attorneys need to keep each other or hold each other accountable for following the rules. And when one of the parties believes that their opponent have violated the rules or procedures of the courtroom, then they could say, "Objection, Your Honor," and then they would state the objection that they have to their opponent's introduction of evidence or their opponent's etiquette. And the judge ultimately makes the ruling on whether that opposing attorney had violated the what are called the rules of evidence. So you would have the prosecutor may say, "Objection, Your Honor, this is hearsay," and the judge would then follow that up with "Objection sustained" if the judge believes that yes, this is a violation of the rules of evidence, or if the judge says "overruled," that's the judge conveying that the rules of evidence have not been violated, and any evidence that was objected to is admissible in court. So the judge, what the judge is doing there is protecting the rights of those involved, making sure that everybody plays by the same rules and that the defendant is ensured a fair trial. The judge makes sure that the rules of evidence are followed. The judge determines the facts of the case and renders judgment only in a non-jury trial. There's two different types of trials. You have a jury trial and you have a bench trial. Now, it's up to the defendants as to whether they want a jury trial or not. In criminal law, a defendant has the right to a jury of his or her peers, but some defendants choose to waive their right to a jury trial and instead opt for a bench trial. In a bench trial, there is no jury. The only person present in the courtroom, well, I shouldn't say the only person present in the courtroom, but the only person that renders a judgment, the final judgment, is the judge himself or herself. The judge also instructs the jury in the trial. So right before the jury breaks for what's known as deliberation, they go into their private room to discuss the evidence in the case and then ultimately determine whether the defendant is guilty or not guilty. The judge first has to explain the law to the jury. And the reason why the judge has to do this is because the jury, they're not legal experts. The jury are what are known as laypersons. They're not experts. You may have a doctor, a garbage man, a school teacher, a police officer, a janitor, and they're all sitting on the same court or the same jury together, but none of those individuals are experts in law. So who explains the law to them? It's the judge's role to instruct the jury in a trial court. The last thing that a judge does in a trial court is sentence sentences convicted criminals. So once a jury renders a judgment or issues a verdict of guilty, the judge then makes the determination of what the penalty is going to be for violating the law. Now, it should be noted that this step does not take place if the defendant is not convicted of the crime that they had been charged with. If the jury finds the defendant not guilty, then obviously there is no sentencing that takes place. One of the last things that we're going to talk about today is the jury selection process. There are two amendments in the Constitution's Bill of Rights that deal with juries. The Sixth Amendment gives you and I a right to a trial by jury. The Seventh Amendment gives us a right to a trial by jury in civil cases at the federal level. Now, juries, though, are not used as often as you may think they are. In criminal cases, as I mentioned before, the defendant decides whether or not to have a jury. But many criminal cases, up to 95% of criminal cases, don't even go to trial. About 95%, actually I think it's over 95, I want to say it's like 98% of all criminal cases are never go to trial but end in plea bargains instead. A plea bargain is when you have the prosecutor strikes a deal with the defense attorney in exchange for a guilty plea. In civil cases, many civil cases, lawsuits, result in out-of-court settlements or bench trials, but usually they result in out-of-court settlements, which are kind of the civil version of plea bargains. Settlements are when you have the plaintiff's attorneys sit down with the defense attorneys and they strike a deal on compensation. So, for example, you have Colin Kaepernick. Colin Kaepernick sued the NFL for collusion. He was claiming that the NFL owners of all 32 teams were colluding or kind of working together against him to keep Colin Kaepernick out of the league. Well, behind closed doors, you had the NFL's attorneys and Colin Kaepernick's attorneys. They reached a settlement to avoid the court process. So Colin Kaepernick received an undisclosed amount of money, which one could assume is in the tens of millions of dollars. Juries, how large are juries? Juries are generally 6 to 12 persons, more often 12 people. Federal criminal cases require 12 people sitting on the jury. They also require unanimous verdicts in criminal cases. So we're going to watch a movie pretty soon called 12 Angry Men. And that's how you are going to remember this number 12 is through this movie, 12 Angry Men. In 12 Angry Men, you have a jury that goes into the deliberation room and they keep talking and talking and talking until they reach a unanimous verdict on the case. Unanimous means everybody needs to be in agreement. In criminal cases, in all but 2 states, there are 2 states, I want to say it was Oregon and Maine, maybe Nebraska, but in all but 2 states, a unanimous verdict is required, which means that it must be 12-0 for guilty or 12-0 not guilty. If it is 11-1 or 10-2 or 9-3, then the jury needs to keep deliberating, keep talking until ultimately all 12 people can be in agreement on a verdict. If that is impossible, and ultimately the judge determines if the jury has been deliberating for long enough, but if that is impossible and there's just 10 people that say guilty, 2 people say not guilty, and nobody's changing their mind, and they've been talking for hours on hours and hours and hours, then that is what's known as a hung jury. In a case of a hung jury, the judge will give the prosecutor an option to either drop the charges or try the criminal, or I shouldn't say criminal, try the defendant again with a whole new jury. Oftentimes, prosecutors will just drop the charges in that case, just because the court process is extremely time consuming and expensive, and to retry a defendant all over again, it usually takes up a lot of a prosecutor's resources. So, jury duty. You may be serving on a jury pretty soon, so you should know about this. Jury, and in order to be summoned for jury duty, and to be summoned for jury duty, a clerk at a court pulls from 2 different lists. 1, social security numbers, and 2, driver's license numbers. If you have either a social security card or a driver's license, you're going to be on this list. And if you have your name called, let's say your number is called, you're going to get a jury summons in the mail. And in order to receive a jury summons, you have to, 1, be a U.S. citizen. So you cannot be from a different country, or if you have been living in the United States but have not yet achieved U.S. citizenship, you will not be called for jury duty. You need to be at least 18 years old, which is why you're not currently eligible for jury duty, but seniors, you're not too far away from this. Most of you are 17 years old, about to turn 18. You have to be able to speak and understand English. This is a pretty obvious one. If the court process is conducted in English, you don't want somebody that only speaks Portuguese sitting on a jury. And then you have to be a resident of the applicable state. So if you are living in Illinois, you are not going to receive a jury summons for the state of Texas. You won't have to serve on a Texas jury. You'll only be serving on Illinois juries. So how is it determined who sits on a jury? Once you've received a jury summons, it doesn't necessarily mean that you're going to be sitting on the jury. My buddy Anthony, for example, he received a jury summons, but he said to me, I got to miss work. I got to go report for jury duty. And he said that he sat there for so many hours and he didn't even get to witness a trial. And what I explained to him was that he was partaking in the jury selection process, what's known as a voir dire examination. And this is where potential jurors are questioned by both sides to determine which ones best fit their case. So you have anywhere from 30 to 60 people generally are called for jury selection, voir dire examination. And both the prosecutor and the defendant, they get to ask questions about the background of these potential jurors to determine which ones would be most likely to find in their favor. Each side gets a certain amount of peremptory challenges. Peremptory challenges. This is a certain number of predetermined exemptions that each side is granted. So you get to dismiss a certain number of people without giving a reason to the judge. And there's a lot of research that goes into peremptory challenges. Once you've used up all of your peremptory challenges as an attorney, then you have to remove for cause. Removal for cause is asking the judge for a prospective juror, to be dismissed because he or she is incapable of rendering a fair and impartial verdict. So you have to be able to give a valid reason to the judge as to why you are removing people if you have already run out of peremptory challenges. And once that pool of 30 to 60 people is narrowed down to just 12 people, you have your jury. Now I want to show you a brief video here of voir dire examination so you can really wrap your head around what this looks like in practice.
Do you think as a juror you would be able to set aside any prior opinion you might hold about the savings and loan industry? That was a question, sir.
What? Do I like bankers?
Your Honor, may I have a minute, please, to confer with my colleagues?
You may.
Dumble. While you're at it, let's get rid of number 4, 6, and I'd say lose number 12, except the prosecutor's gonna fuck up and do it for us.
Don't say that
Number
word.
6. You're kidding, right? She's my first choice. She's my first pass. And 4? With the dreadlocks. That's crazy. That's a defendant's juror if I ever saw one. Did you see his shoes? Look, kid, maybe down in Florida, you are the next big thing. This is New York, Manhattan. We're not squeezing oranges here. He polishes those shoes every night. He makes his own clothes. He may look like a brother with an attitude to you, but I see a man with a shotgun under his bed. And woe betide the creature who steps into his garden. And number 6, your favorite, she's damaged goods. She's a Catholic school teacher. Believes in human frailty? No. There's something missing from her. She's wrong. She wants on this jury. Somebody hurt her and she wants revenge. How the hell do you know that? I don't know. Look, either you put a stop to this happy horse shit or I walk. Walk. All right, here's the deal. I lose with your jury, you do the explaining.
Your Honor, may I continue? We'd like to excuse jurors 3, 4, and 6.
So there you go. You saw the attorney using his peremptory challenges to excuse those jurors, but did not have to provide a reason to the judge for doing so. All right, that's all I got for you. I hope you learned something, and I'll see you next time.